I want you to think about one of the most dangerous financial rules in America, because it is not dangerous in the way people usually imagine danger. It does not arrive as a market crash. It does not arrive as a bad investment. It does not arrive as one large bill that you can see coming. It arrives quietly after a lifetime of doing what many people think is responsible. You work, you save, you buy a home, you help your children and grandchildren when they need help. You give gifts at holidays, you try to leave something behind. Then one day, late in life, when your health changes and you need long-term care, the system looks backward over the previous 5 years and decides that what you thought was generosity was actually a penalty event. That is why I want you to understand the Medicaid 5-year look back. The name sounds technical and harmless, but it is not harmless. It is not really about looking back. It is about deciding whether the money you moved, the checks you wrote, the car you signed over, the help you gave to family, and the house you hope to protect will now be used against you at the exact moment when you are least able to fix it. If you are 65 or older, if you own a home, if you have savings, if you have children, or if your parents are getting older, this is one of those rules you cannot afford to discover after the fact, because by the time most families discover it, the clock has already beaten them. The rule works like this: if you eventually need long-term nursing home care, and that care costs more than $108,000 per year on average, most families cannot pay that bill for very long. Even people who spent their whole lives saving carefully can be consumed by that number. A few years in a facility can drain cash, investments, and retirement accounts that took decades to build. So when the private money runs low, people apply for Medicaid. That is when the real examination begins. Before Medicaid pays, a caseworker can review bank statements, property records, gifts, transfers, and asset movements. Going back 60 months, 5 full years, the system is not only asking what you own today, it is asking what you used to own, where it went, who received it, and whether Medicaid believes that transfer should count against you. That is the part many people miss. They think, I do not have much money left, so Medicaid will help. But Medicaid does not only look at what remains, it asks whether assets were transferred away before the application. And if the state can impose a penalty period. That penalty is not a fine in the ordinary sense. It is much more dangerous than a fine. The state takes the total amount of non-exempt transfers made during the look-back period and divides it by a number called the regional penalty divisor. In many places, that divisor sits around $10,000 or $12,000 per month. Though it varies by state, the result is the number of months Medicaid will refuse to pay. So imagine a person gave away money over time, not because they were trying to hide assets, but because they were helping family. Maybe they helped a grandchild. Maybe they helped with a car repair. Maybe they paid for part of a wedding. Maybe they gave holiday checks. Then they need care. The state adds up those gifts and says, based on this amount, you are ineligible for Medicaid for a certain number of months during that time. The nursing home still wants to be paid. The bill keeps coming. The facility is not going to say, I understand that the penalty period is inconvenient. It will expect payment. That is the trap. You no longer have the transferred money, so you cannot pay. But because you transferred the money, Medicaid will not pay either. That gap is where families get destroyed, and when the bill cannot be paid, the first major asset in the line of fire is usually the house. Most people misunderstand this because they confuse tax law with Medicaid law. They hear that the IRS allows an annual gift exclusion. They hear a number like $19,000 per recipient, and they conclude that if a gift is allowed under tax law, it must also be safe under Medicaid. That is a very dangerous assumption. The IRS and Medicaid are not the same system. They have different purposes. They have different rules. They do not define the same transfer the same way. A gift can be perfectly legal for federal tax purposes and still create a Medicaid penalty. That distinction is where many decent families make a very expensive mistake. A grandfather writes a check to a granddaughter at Christmas. A mother helps her adult son through a difficult month. A retired couple helps pay college tuition. A parent sells an old car to a nephew for $1. A widow forgives a family loan because she does not want to fight with her children. Under ordinary family logic, these things can feel normal. Under Medicaid logic, they may be treated as uncompensated transfers. The system does not care that it was a birthday. It does not care that it was a holiday. It does not care that you did not know. It does not care that the IRS did not object. It cares whether value left your estate during the look-back period and whether you received fair market value in return. That is the machine. And machines do not become sympathetic because the facts are emotionally understandable. They follow rules. That is why this is so dangerous for seniors who live normal, generous lives. Most of them were never trying to game anything. They were simply behaving the way parents and grandparents behave. They helped, they gave, they trusted that if something was permitted in ordinary life, it would not later become a legal and financial trap. But systems punish misunderstanding, not just fraud. That is a principle I have learned over and over in markets, economies, and governments. When you do not understand the system, you can lose even when you believed you were acting honorably. Now consider what happens when a married couple is involved. Many people believe the healthy spouse is fully protected if the other spouse enters a nursing home. There is some protection, but it is far narrower than most people think. The protection is called the Community Spouse Resource Allowance. In 2026, the maximum amount of countable assets the spouse at home can keep is $157,920. When people hear that number, they often think it sounds large, but you must think about what that number has to do. It is not vacation money. It is not excess money. It is the reserve for the healthy spouse's life. It must cover property taxes, insurance, repairs, food, transportation, medications, Medicare premiums, emergencies, and everything else that can happen over the next 10, 15, or 20 years. When you spread that amount over a long life expectancy, it becomes much smaller than it looks. At the same time, the spouse in care may be in a facility costing more than $9,000 per month. This creates a cruel imbalance. The institutional care bill is enormous and immediate. The healthy spouse's allowed reserve must last for years. Families look at the rule and say, how can this possibly work? The answer is that it was not designed to protect comfort. It was designed to determine eligibility. There's a big difference between those two things. The state is not asking whether the spouse at home will feel financially secure. It is asking whether the applicant meets the rules. That is why relying on hope is not a plan. Then there is the house. This is the emotional center of the whole problem. For many families, the house is not just an asset. It is the place where children grew up. It is the one thing the parents believe they can leave behind. It is the anchor of the family balance sheet. And many seniors believe the house is safe because Medicaid does not force them to sell it while they are alive and living in it, or while a protected spouse continues to live there. That belief is only partly true. The house may be exempt while the person is alive under certain rules, but that does not mean the house is permanently protected. After the Medicaid recipient dies, the Medicaid estate recovery program can begin. Federal law requires states to seek recovery from the estates of Medicaid beneficiaries who received benefits after age 55. That means the state can file a claim against the estate, and in many estates, the largest remaining asset is the home. The family may expect the house to pass to heirs. Instead, the heirs receive a claim. They may be told to pay the claim or sell the home. The number can be large. The average estate recovery claim now exceeds $74,000, and in some states, it can be far higher. It can reach hundreds of thousands of dollars when care lasted a long time. This is why the belief that the house is always safe is so dangerous. The house can be exempt at one stage and vulnerable at another. That is how systems work. They do not always take the asset at the moment you expect. They wait until the rule allows recovery. This is also why the problem does not always end with the parent's estate. In many states, there are old laws called filial responsibility laws. These laws can allow adult children to be held responsible for a parent's unpaid care bills. For decades, many people ignored these laws because they were not often used. But old laws do not disappear just because people stop thinking about them. They can come back when the incentives change, when nursing homes cannot collect, when estates are insufficient, when state recovery does not cover the bill. The pressure moves somewhere else. And sometimes that pressure moves to the adult children. That is the part many families cannot believe until a letter arrives. They thought long-term care was the parent's problem. Then they discover it can become an estate problem. Then they discover it can become a children's problem. In system terms, the liability searches for a balance sheet. It looks for somewhere to land. Let me make this concrete. Imagine a widow in Ohio. She is 78 years old. Over 4 years, she gives $45,000 to her daughter. Not in one dramatic transfer. Not in a secret offshore arrangement, just birthday checks, holiday help, and support during family needs. Then in month 47, she enters a nursing home. The state reviews the previous 60 months. The $45,000 is counted. The state divides that amount by the Ohio penalty divisor, which in the example is $7,463 per month. That creates roughly a 6-month penalty. During those 6 months, Medicaid does not pay. The nursing home charges $9,200 per month. The bill becomes $55,200. She does not have that money. A lien is placed against the house. She dies 8 months later. Then estate recovery produces an additional claim for care costs. The daughter receives a letter explaining that the house may be sold by court order. What destroyed that family was not one reckless decision. It was the interaction between ordinary transfers, timing, long-term care costs, Medicaid rules, and estate recovery. That is how these traps usually work. They are rarely one thing. They are a chain. A transfer creates a penalty creates an unpaid bill creates a lien, a death activates estate recovery targets the home sale destroys the inheritance. And in some states, whatever remains can move toward the children. If you only look at one link, you do not understand the chain. The chain is the risk. Now, there are strategies that attorneys sometimes use when the family is already in trouble. One is sometimes called the half-a-loaf strategy. The idea is that if there is no 5-year planning runway left, a family may give away part of the assets and use the remaining part to pay through the penalty period created by the gift. It does not save everything. It is not ideal. It is a damage control strategy. It requires timing. It requires precision. It requires someone who knows Medicaid planning in that state. And it generally must be done before the Medicaid application is filed. Once the application is filed, the strategy may no longer work. This matters because many people wait until the hospital discharge planner tells them that a nursing home is needed. That is when the family starts asking questions. At that point, many of the best options are gone. The most powerful planning must be done before the crisis. That is an uncomfortable truth, but it is the truth. The families who lose the most are often not the families who had no assets. They are the families who had assets but no plan. They had a will. They had a power of attorney. They had good intentions, but they did not have a Medicaid plan. And a will does not solve a Medicaid problem. A will says where assets go after death. It does not stop those assets from being consumed or recovered before they ever reach the heirs. That is why the document I want you to know by name is so important. It is called a Medicaid Asset Protection Trust. In some states, there is also a document for the home called a Lady Bird deed. It is available in states including Florida, Texas, Michigan, West Virginia, and Vermont. And it can accomplish part of the protection for the home specifically. But the broader planning tool is the Medicaid Asset Protection Trust. It is an irrevocable trust. That word matters. Irrevocable means you cannot simply take everything back whenever you feel like it. If you could freely take the assets back, Medicaid would usually treat them as still available to you. So the trust has to be structured correctly. The house, savings, and investments that are moved into the trust are no longer owned directly by you. The trust owns them depending on the structure. You may still live in the house. You may still receive certain income from trust assets, but you do not have unrestricted access to take the assets back. That loss of control is why many people hesitate. It is also why the planning works when done correctly after the trust has been funded and the 5-year look-back period has passed. The assets inside the trust may no longer be counted for Medicaid eligibility. The look-back can no longer reach them because the clock has run. Estate recovery may not be able to reach them because they are not passing through the estate in the ordinary way. The house can pass to heirs outside of probate and outside of the recovery process if the trust is properly drafted and funded. But the key phrase is properly drafted and funded. It is not enough to sign the trust. Assets must actually move into it. The 5-year clock does not begin when you think about planning. It does not begin when you call a lawyer. It does not begin when you schedule a meeting. It begins when the assets are transferred into the trust. That is why delay is so expensive. Every day you wait is one more day before the clock starts. And if care is needed before the 5 years have passed, the protection may be incomplete. This is one of the reasons many ordinary estate plans fail. A senior walks into an attorney's office and says, "I need a will." The attorney prepares a will. Maybe the attorney prepares a power of attorney and healthcare directive. Those documents can be useful, but if nobody discusses long-term care, Medicaid eligibility, the look-back period, and estate recovery, the core risk remains untouched. A standard will may cost a few $100s. A Medicaid Asset Protection Trust can cost thousands, often between $4,000 and $12,000 when done correctly. That feels expensive until you compare it to 1 year of nursing home care or one estate recovery claim against the house. The problem is that people compare the trust to a cheaper will. That is the wrong comparison. You compare the trust to the cost of losing the house. You compare it to years of care costs. You compare it to the inheritance being redirected to the state when you frame it that way. The math looks very different, but you must ask the right question. A general estate attorney may not bring it up. Some attorneys do not specialize in this. Some may prepare wills all day and rarely do sophisticated Medicaid planning. That does not mean they are bad attorneys. It means you need the right kind of expertise for the specific risk. The credential to look for is Certified Elder Law Attorney, often shortened to CELA. You want someone whose practice is built around elder law and Medicaid planning, not just general documents. This is a specialized area. The rules vary by state. The timing matters, the transfer rules matter. The deed matters, the trust language matters, the income rights matter, the spouse's rights matter, the order of operations matters, and when the order of operations is wrong, the family can lose options permanently. So if I were approaching this problem in a practical way, I would not begin with emotion. I would begin with inventory. I would pull the last 60 months of bank statements and look for transfers to family members. I would not do this to blame anyone. I would do it to understand exposure. What checks were written, what cars were transferred, what loans were forgiven, what tuition was paid, what property changed hands, what charitable gifts were made. Which transfers might Medicaid question? You cannot manage what you refuse to see. That is a principle in investing. It is also a principle in family planning. Then I would locate a qualified elder law attorney, not a friend who did a real estate closing, not the lawyer who wrote a simple, 20 years ago, a specialist. I would ask directly about a Medicaid asset protection trust. I would ask whether a ladybird deed is available in my state and whether it makes sense for the home. I would ask how the house should be titled. I would ask what happens to income. I would ask how the trust affects taxes. I would ask how the plan handles the spouse. I would ask how the plan handles the 5-year look back. I would ask what happens if care is needed in year 2, year 3, or year 4. You want to understand not just the ideal case, but the failure cases. Good planning is not pretending risk disappears. Good planning is knowing which risks remain and how large they are. Then I would fund the trust immediately if the plan calls for it. This is where many people fail. They sign documents and put them in a folder they feel finished. But the assets were never retitled. The house was never deeded into the trust. The accounts were never moved. The paperwork exists, but the protection never began. That is like designing a bridge and never building it. The clock starts when assets move, not before. This is why procrastination is so costly. The most expensive day is not always the day the nursing home bill arrives. The most expensive day may be the day after you should have started the 5-year clock. That day looks ordinary, nothing happens, nobody calls, no bill arrives, but the opportunity cost begins accumulating silently. 5 years later, the family may discover that one ordinary day was the difference between protection and exposure. That is how long-term systems work. The consequences are separated from the decision by time because the consequence is delayed. People underestimate it. Markets work that way, debt works that way, health works that way, estate planning works that way. The damage is rarely obvious on the first day. It becomes obvious when the system reaches the point of enforcement. I want to be careful about the emotion here. The purpose of understanding this rule is not to become cynical or afraid. It is to become prepared. The government did not invent long-term care costs because it dislikes families. Medicaid is a safety net program with rules designed to preserve the program for people who qualify. But from the family's perspective, the system can be brutal if you discover it too late. Both things can be true. A rule can have a policy purpose and still destroy people who do not understand it. That is why the answer is not anger alone. Anger without action does not protect a house. Confusion without action does not protect savings. Fear without action does not protect children. Only planning can do that, and planning must happen before the crisis. If you are older and own a home, do not assume the house is protected because you have a will. If your parents are older and own a home, do not assume that a conversation about inheritance is enough. If your spouse might need care one day, do not assume the healthy spouse will automatically be fine. If you have been giving money to family, do not assume that a legal tax gift is safe under Medicaid. Each of these assumptions can be wrong, and in this area, being wrong is expensive. This is why I think in terms of principles. The first principle is that systems follow incentives. The nursing home wants to be paid, the state wants to recover costs. Medicaid follows eligibility rules. Families want to preserve dignity and inheritance. Those incentives are not the same. When incentives conflict, the family that planned first usually has more choices. The family that waits usually has fewer. The second principle is that timing matters. A Medicaid asset protection trust is powerful only if the 5-year clock has time to run. A half-a-loaf strategy may help only before certain filings occur. A ladybird deed may help only if state law permits it and the deed is drafted properly. Waiting turns strong options into weak options. Waiting turns planning into triage. The third principle is that ownership matters. What you own directly can be counted. What passes through your estate can be recovered. What is transferred improperly can be penalized. What is placed into the right structure early enough may be protected. The legal form of ownership is not a technical detail. It is the difference between an asset being reachable and unreachable. The fourth principle is that family generosity must be coordinated with the rules. I am not saying do not help your children or grandchildren. I am saying understand that the system may treat help as a transfer. If you want to help, plan it, document it, understand the look-back period. Know the consequences before the check is written. The fifth principle is that the right professional matters. This is not an area for guessing. It is not an area for downloading a random form. It is not an area where a small error is always fixable. You want someone who does this work repeatedly and knows the state rules. If someone tells you a will is enough, ask what happens under Medicaid estate recovery. If they cannot answer clearly, keep looking at the end. The hardest thing about this rule is not that it exists. The hardest thing is that it hides in plain sight. The look-back period is not secret. Estate recovery is not secret. Community spouse rules are not secret. Filial responsibility laws are not secret. Medicaid asset protection trusts are not secret. But most families do not learn the pieces until the crisis forces them to learn all of them at once. That is the mistake. You do not want to learn a complex system under emotional pressure. You do not want to learn it while a parent is being discharged from a hospital. You do not want to learn it after a nursing home bill has already started. You do not want to learn it after 5 years of casual family gifts have created a penalty. You want to learn it while time is still your ally. Because once time is no longer your ally, every decision becomes more expensive. If you remember nothing else, remember this. The 5-year rule is not only about what you have, it is about what you did with what you had. It is not only about your money, it is about your timing. It is not only about qualifying for care, it is about whether the house survives the process. And it is not only about you, it is about the spouse who stays home, the children who inherit the problem, and the family that thought it had done enough because a will was sitting in a drawer. The will tells people what you wanted. The Medicaid plan determines whether anything is left to carry out those wishes. Those are not the same thing. So do not wait for the crisis. Do not wait until care is needed. Do not wait until the hospital gives you a list of facilities. Do not wait until the first nursing home bill arrives. Do not wait until the state starts asking for bank statements. Find the transfers. Find the right attorney. Ask for the Medicaid Asset Protection Trust by name. Ask about the Lady Bird deed if you live in a state where it applies. Fund the trust if that is the right strategy. Start the 5-year clock. Tell your adult children what the rule is, because this is not only an aging issue, it is a family balance sheet issue. The people who survive systems are not always the smartest people. They are often the people who understand the rules before the rules are enforced. That is the difference here. Most families do not lose the house because they were careless. They lose it because they were late. And in this system, late can be the most expensive word in the English language